the marathon testimony of Nigel Wright at Mike Duffy's fraud trial. It's been going on for a week, and by most accounts, the testimony has been measured, even though in the media, the lines have been blurred as to who's actually on trial, Mike Duffy or Nigel Wright.
You know, after a week, you'd think the lawyers would have exhausted all the questions they'd have and everybody would be tired of hearing from the same witness, but no, the questions keep on coming.
Well, joining us now to explain how lawyers and witnesses prepare for such a grueling inquisition, we have our criminal lawyer friend, Jeff Manishen, who also has experience working as a Crown attorney, which is great. You can see it from both sides. So, Jeff, what's the longest you've ever had a witness on the stand? I mean, you know, going on the 6th day, I guess, today. Is that common?
Very uncommon.
Okay.
I think the longest for me might have been 2 days.
Really?
6 days, and yet I know of cases, and I've had trials where lawyers have had witnesses on the stand for several days. It does happen from time to time. I think what largely drives it is the amount of material you have to work with and the amount of material you want to cover. Some lawyers could take a given witness and say, I need 3 days, and another lawyer might say, I'll need a day, and another lawyer might be 4 hours. It's what do you cut, it's what do you want to lead.
So Jeff, as a lawyer, and let's say you're a defense lawyer here. You want to come up with proof. You want to ask questions so that it appears as if your client is not guilty. You're putting the burden of proof on the prosecution, on the Crown attorney, I guess. And is it a different tactic or strategy that you have to devise if you are the Crown attorney in a case like this?
Well, sure. As a Crown, and the Crown in this case took Mr. Wright through his evidence in a relatively short period of time, you decide what you want to lead that you think the witness can provide assistance on with respect to the elements of the offense that you're looking to prove in issues such as fraud or such as bribery, the nature of the transaction that gave rise to the charges. And if you've established that factual basis, you may feel that you've done your job. There are cases where, to be able to paint the picture fully as a Crown, you may feel it necessary to go through a number of documents, a number of emails, a number of communications in a more detailed fashion. Again, it's a judgment call, what you feel is sufficient that presents the picture fully. But the defense isn't limited to what the Crown chooses to lead. And so you're going to work backwards from what are the elements of the offense the Crown has to establish, what's the basis of the defense position, what's the evidence you're going to be leading when you call any defense evidence, assuming that you do. What are the areas you want to challenge the Crown witness on? Specific facts, on the witness's credibility, on the witness's reliability, accuracy of memory. What are the extra details that might assist the court to say, look, I don't buy this witness, I don't buy the case for the Crown, I don't like the nature of the prosecution generally, and all those things can go into the mix to be able to say the Crown hasn't proven the case.
Jeff, I want to ask you about some languaging, which I found interesting. I'm going to quote a couple things that Nigel Wright said. He was asked a question. He said, he may have dropped into the office. I think I wanted him on the call. Now, these are words that would suggest you're not really sure. Is that done on purpose, leaving yourself open for, well, that's what I thought, but I was wrong. Now you're telling, now I know I was wrong, versus yes, no, that's what happened.
Two ways to play that, Liz. Number one, we could say that a witness is telling the truth and genuinely is not certain, but says, I think so, or I may have, and it precisely describes the extent of the level of certainty that the witness has for the testimony. There are others, though, would characterize phrases like that as weasel words. Words to be able to let you slip and slide away from what you might be confronted with. If you don't know what it is you're going to be challenged about, it could be, for example, whether or not someone such as Ray Novak was present at a given meeting or present on a particular phone call, and you're the witness and you don't know what they have or don't have to be able to show he did participate.
That's exactly what the question was. Aren't you smart?
Oh, yeah, well, you know, that's the way I've been looking at the evidence and thinking about the case.
Right.
You give yourself the wiggle room where it's, oh, okay, so he was there. All right, I made a mistake.
Right.
You don't want to commit yourself sometimes, and as a defense counsel, you may well look to pin the witness down. You can read those sort of phrases and say, I smell a lie here. I've had instances where a witness might say, a police officer might say, I don't have that in my notes, but I have an independent recollection. Well, I use those words sometimes as the right basis to challenge. I think so, I'm pretty sure, I seem to recall, those are all things that you can use, reading off what the witness says to challenge him or her.
Jeff, it sounds to me that if you were ever to be a witness in any kind of a case, you would be a tough nut to crack. I wouldn't want to be the lawyer to ask a lawyer such as you questions, because you're going to give me answers in legalese. You're not going to, I don't know, you know the law. And now you're going up against someone else who knows the law too. Is a lawyer ever intimidated by a witness who is another lawyer?
Well, I've actually testified on a few different cases, Mark. And rather than using legalese, the approach I use is I call it precision language to describe accurately and honestly and as reliably and truthfully as I can exactly what I could recall. And I've been able to handle cross-examination that way. Yeah, it's a challenge to be able to cross-examine a lawyer, but sometimes you might rely upon that fact that that lawyer may think he or she is smarter than you.
Oh.
You may well look to trap them. You can have it sometimes with expert witnesses. Sometimes there's a bit of mind games going each way. And sometimes you may well lead that intelligent witness down a path that you're looking to contradict them on. You can tie them up in knots sometimes with their own level of intelligence if they aren't telling the truth.
You know, everybody knows what's at stake here. You know, Nigel Wright wrote the check to cover Duffy's expenses. Did the Prime Minister know? Wright has said that he didn't realize the ramifications of what he did, that he made a mistake. He said, I thought I'd be publicly embarrassed if anybody found out, but I didn't think it was going to have any other implication. I mean, once you've got that answer, how much more can you debate it? If that's what he thought, then that's what he thought, right?
Well, I guess what I'd say to you with respect to that, Liz, I might use an answer like that to undermine his credibility. The position of the defense is that Duffy was essentially pushed, extorted, coerced into accepting the money and going along with what he was pushed into doing, that he didn't have any dishonest intent. And you may well look to challenge Nigel Wright's claim, gee, I had no idea. He could be painting himself as entirely more naive and less believable than you'd like to be able to have if you were relying upon his testimony. You may look to challenge that. I have to say, too, by the way, one comment on this case. If there was ever a case that could have been televised, this would have been it.
Yeah.
I'm surprised, actually. It would have been a great one for the media to have applied at the outset of the trial or in advance to say, we want to cover this, because it's a trial before a provincial court, a judge of the Ontario Court of Justice. Public figures, there's a real diminished expectation of privacy, and the public would have a great interest in this case. So I, for one, regret this trial wasn't televised.
Big ratings. It would be big ratings.
Big time.
Well, we're giving a sneak peek right here, so we'll take the ratings. Thanks. Jeff Manishen, criminal lawyer, appreciate your expertise on this. Thank you.
My pleasure. Thank you.
Thanks, Jeff.
When we come back, a young Liberal candidate in Calgary, well, she's dropped out of the race for using some fairly poor judgment with tweets she sent when she was 17.
You know, Liz, poor judgment is an understatement. Her comments were totally offensive and unbecoming of someone who wants to run for federal office. We'll debate that when Square Off returns after this.